This is arguably the most serious case that has come in front of an Ohio court in a very, very long time. The wiping out of an entire family. Can't we treat this with some seriousness and the gravity that it deserves? A self-described dog bite expert took center stage at a highly contested hearing for the murder retrial of a Boston area woman. Plus, an Ohio courtroom is stunned by the judge's sentencing of a man responsible for 8 cold-blooded murders. And a Florida dentist found guilty in 2023 for his role in the murder for hire of a law professor suffers a setback in his attempt to have his conviction overturned. All this and more this week on Courtroom Confidential. We are very glad to be returning to our normal schedule here at Courtroom Confidential, but we wanted to take a moment to extend our prayers to those affected by the devastating fires in Los Angeles. Our friends and family are safe, but many have lost homes, and the community is experiencing a loss that they will not be recovering from for many years to come. We are recording this episode on Thursday, January 9th, 2025. I am still getting over losing my voice, so bear with me, but let's jump right in. First, a key defense expert in the Karen Reed case returned to the courtroom Tuesday for the second half of a lengthy hearing to decide whether her testimony will be permitted in the upcoming retrial. Norfolk Superior Court Judge Beverly Cannoni is now considering the prosecutor's request to exclude the expert, according to the Boston Herald. She doesn't have the qualifications. She doesn't have the experience. She doesn't have the methodology, Special Prosecutor Hank Brennan told Cannoni at the end of Tuesday's hearing. Quote, but a willingness to tell opinions that are speculative, factually wrong, not based in science and math, should disqualify her from giving another baseless opinion about a so-called dog bite wound, Brennan added. Dr. Marie Russell, a retired emergency room doctor from a top-tier trauma hospital in the Los Angeles area, asserted that in her professional opinion, dog bites caused the injuries found on John O'Keefe's body, as well as the holes and tears in the clothing he wore on the morning of his death, January 29, 2022. Dr. Russell, who also worked as a forensic pathologist and medical examiner, refuted the prosecution's claim that a motor vehicle crash caused the injuries, stating that none of the wounds matched the typical pattern seen in motor vehicle strikes. In the heated cross-examination, Brennan suggested Dr. Russell was relying on her subjective opinion. Dr. Russell testified to the same opinion during the first trial that ended in the summer with a deadlocked jury. Also Tuesday, Brennan filed a motion seeking to block 2 other experts, crash reconstructionist Daniel Wolf and Andrew Rentschler, from testifying again in the second trial. This case will continue to January 31st with further evidentiary hearings. Well, what is happening here? Folks, there is a new sheriff in town with this brand new prosecutor, and he is challenging everything. Now, the first question to ask is, can the judge reverse her decisions from the first trial? Can Cannoni have allowed an expert at the first trial and now pull a 180 and say she's not allowing that same expert to testify in the second trial? The simple answer to that is yes. Absolutely, she can. This is a new trial. It's got new evidentiary hearings, new arguments being made. She can make that decision. Now, the defense has done a pretty good job of highlighting to her that she's already basically allowed this expert to testify as an expert. And so she would essentially be reversing her own decisions. Now, I think that Cannoni doesn't care about that. I think if she wants to, she could prohibit this expert from testifying. And she might want to. She might want to say that she never really was presented with these arguments, that the prosecution never really objected in the way that they have now with these evidentiary hearings, and therefore she wasn't really given the opportunity to make these rulings. But the question ultimately is, will Cannoni prevent Dr. Russell from testifying in the second trial? I believe the answer to that is no. I believe that the defense has laid out the groundwork for establishing why this witness should be able to testify as an expert. First, a couple of initial hurdles that must be crossed in order to present an expert at trial. Does the testimony assist the jury? In other words, You can't just call an expert about anything. You can't call an expert on jaywalking. I mean, there are some things that jurors don't need help with, but this seems to be an area where jurors might not know just by looking what is and what is not a dog bite injury. So yes, it can assist the jury. Is she qualified? And that was really the question being argued here. Is she qualified to testify to that as an expert? I think the answer to that is, again, yes. She is very qualified as a doctor. She has seen many, many different patients, many patients with a wide variety of injuries and illnesses in her time as a physician, including, according to her own testimony, hundreds of people suffering from dog bites. That is enough. It really is not some sort of standard that you have to have written the book and been the only person, on the face of the earth to be able to testify to dog bites before you can testify in a court of law. Having seen hundreds of different dog bites as a physician over the course of your career, I think is probably enough. So why did Brennan try to challenge this, knowing that she probably will satisfy the elements and will be allowed to testify? I think that Brennan knew she would be qualified, but I think he wanted to nail down her testimony to some very specific points. Now he's got her locked into what she's going to testify, to things that she knows and things that she does not know. A lot of that questioning, that cross-examination of Dr. Russell had to do with, I believe, him setting up how his experts are going to attack her testimony. And she cannot now pivot from that. This was testimony taken under oath. She is locked into what she said during this cross-examination by Brennan. And if she tries to deviate, if she tries to pivot, if she tries to somehow answer some things that she didn't answer as well during that cross-examination at trial, he will use these transcripts to impeach her with that. And he will call experts to impeach the testimony that she is locked in now. It's essentially like he treated this like a prelim and got a preview of the defense expert. But was this a loss for the defense? I don't think so either. First of all, I think that she did prove herself to be qualified. I think she will be able to give those opinions that was a dog bite. And one thing more, I think she also showed that she's qualified to say that this was not a vehicle strike. In the cross-examination of Dr. Russell, Brennan also exposed how she has seen hundreds of different people, patients, hit by vehicles. And so now I think the added testimony of saying not only was this a dog bite, but I can tell you it was not a vehicle strike is something that I believe she's qualified to answer. Now, does that close the door on it? Does that mean it's the end of the case? No. I am sure that the Commonwealth has waiting in the wings their own experts to say Dr. Russell's got it all wrong. So this will, like many trials, come down to a battle of the experts. But I think the real takeaway from all of this is that no quarter is being given the second trial. They will challenge everything. They are challenging the dog bite experts. They are challenging the cell phone extraction. They are challenging the collision reconstruction. Nothing that we saw the first time around is a given for the second time around. But what do you guys think? Do you think this was a win for the prosecution or a win for the defense? Do you think that Dr. Russell's testimony will again carry the day for the defense? Please let us know in the comments. 2 more family members convicted in the killings of 8 members of an Ohio family received prison terms on Friday for their roles in the 2016 shootings as prosecutors near completion in what has been described as the most heinous crime in modern Ohio history, as reported by the AP. In a Pike County courtroom on Friday, visiting Judge Jonathan Hine threw out the prosecution's plea deal with Edward Jake Wagner and instead provided him with an opportunity for parole. Jake pleaded guilty in 2018 to 8 murders, 5 of which he admitted to being the man who fired the fatal bullets. The murders, which occurred on April 22, 2016, took the lives of 8 members of the Roden and Gilly families in Pike County. Originally, Jake agreed to a plea deal with the prosecution for 8 life sentences without the possibility of parole, sparing him and his family members from the threat of the death penalty as long as he agreed to cooperate with authorities and testify truthfully at any future trials. Instead, Hines sentenced him to 8 life sentences with the possibility of parole after 32 years. Jake's mother, Angela Wagner, was given 30 years in prison for her role in orchestrating the killings, 6 of which she had already served. That sentence was in line with the plea deal she forged with the prosecution. During a hearing for Wagner family patriarch Billy Wagner, held after the sentencing, the prosecution declined to present additional arguments for retaining the death penalty as a potential sentence for Billy Wagner, pointing to a pending appeal in the Ohio Court of Appeals regarding Judge Hines' decision to remove it as an option, despite pressure from Judge Hines that the prosecution continue their arguments. Key questions remained unanswered, including the trial's location and start date, after approving a venue change in November. The trial, originally set for Monday, is delayed pending the appeal's resolution. What is happening here? I am telling you, I have a headache over all that's gone on with this trial, and mainly because of this judge. Let's talk about just a few highlights, okay? First of all, he gives Jake Wagner life. I realize that. But the ability to be paroled after 32 years for 8 murders, 5 of which he's the trigger man for, that is beyond offensive to me. Where I practice in California, first-degree murder with a gun allegation is going to land you 50 years in prison for 1 murder. He got 32 years eligible for parole for the taking of lives, participation in 8 murders, cold-blooded, premeditated murders. No excuse for that in my book. Then the reason that the judge highlighted was that he felt he had to draw some distinction between Jake's brother, who had gone to trial and lost and was sentenced to life without parole, and what Jake had done by cooperating. And oftentimes judges will do this. They will say that there should be some benefit to the person who cooperated and who pled guilty. But that's not to say that there's a punishment for the person who went to trial. But that's almost the way that the judge viewed this here. It was almost as if because his brother had been sentenced to life without parole, and because he had exercised his own constitutional rights to go to a trial, that somehow him being sentenced to the same thing as Jake is unfair. Not the way that we should be looking at this. This isn't a math equation. This is about doing justice. This is about what is the right thing to do. I don't think there's an argument you can make to me that will convince me that somehow a person who took the lives of 8 people should ever see the light of day outside of a prison, should ever walk amongst civil society again. The deal was for the benefit of everyone not seeing the death penalty. That was the deal. That was the benefit to Jake. And he agreed to that. That's the part that kills me as well. The judge is getting involved in an agreement that the defendant already agreed to. If you expect prosecutors to ever want to handle a plea negotiation with that judge in that county again, have yourself another think. Not going to happen. This is going to break down the relationship between the DA's office and the bench in that county for a long time to come, I think. And then the last thing he did is he took this plea deal before Jake had actually satisfied any part of his agreement, which was to testify truthfully at all upcoming trials. He's already testified once, but there's another trial coming up and he hasn't testified. What incentive now does he have to testify truthfully? Think about it. If he refuses to testify, or if he testifies in a way that benefits his father, what is the state going to do about it? They've taken that away from the prosecution. One last thing the judge has done here is he already took the death penalty off the table for Billy Wagner in his upcoming trial. And his reason for that is that he's saying the clock ran out. He's saying that the prosecution essentially took too long in arriving at this plea negotiation. He's just going to take the death penalty off the table to get this trial on the road. The prosecution's response to that was, quote, "Why are you trying to sabotage this case right now?" And I couldn't agree with it more. This is sabotage. This is the death penalty we're talking about. This is arguably the most serious case that has come in front of an Ohio court in a very, very long time. The wiping out of an entire family. Can't we treat this with some seriousness and the gravity that it deserves? We don't just make decisions because we feel like it's taking too long for the prosecution to arrive at that. If they want to take a long time to make the decision of whether or not to seek the greatest penalty we have in this country against a man, then let them take that kind of time in a case of this magnitude. I don't understand the games. I don't understand the lack of consideration for the victims involved. Good on the prosecution for refusing to be bullied by this judge and continue to argue the death penalty issue when it's already in front of the Court of Appeals. I think this judge is afraid of what that court is going to say. I think they're afraid of the condemnation they're going to have for this judge's actions. I think he was trying to avoid that by getting them to reopen the arguments. Good on the DA's office for refusing to do that. But what do you guys think? You think this judge is off the rails as much as I am, or do you think I'm just missing something here? Please let us know in the comments. Charlie Adelson, who's serving a life sentence in the murder for hire of Dan Markell, was denied a request to relinquish jurisdiction back to the trial court by the First District Court of Appeal. The request, filed in October, cited conflicts involving attorney Dan Rashbaum's representation of both Adelson and his mother, Donna Adelson, after she was charged in Markell's murder in 2023. Adelson, a former South Florida periodontist, was found guilty in 2023 of first-degree murder, conspiracy, and solicitation after an 8-day trial in Tallahassee. Judge Stephen Everett sentenced him to life in prison for the murder itself and 30 years each for conspiracy and solicitation counts, with the terms running consecutively. Last September, Donna Adelson's murder trial abruptly imploded on the first day of jury selection. Charlie Adelson's appellate lawyer, Michael Ufferman, announced that his client wouldn't waive conflicts involving Rashbaum. At the time, Charlie Adelson was listed as a state witness in his mother's trial, setting up the possibility that he could be cross-examined by Rashbaum, his previous attorney. Ufferman, in his motion before the appeals court, said Rashbaum's conflict of interest also infected Charlie Adelson's murder trial. He asserted that Donna Adelson, who was listed as a defense witness in her son's trial, was removed from the witness list to protect her and not her son. What is happening here? Well, first, you may think this is a setback for Charlie. And while it is, it's also not. This needed to get in front of the appellate court. I think before anything of any kind of magnitude could be decided on this. Asking for the trial court intervention, I think, was a long shot. Asking for it to be sent back down to the trial court didn't make a whole bunch of sense to me. And I wonder if strategically that just had to do with checking boxes and making sure they had closed all possible objections to their appeal. And as much as I hate to admit it, this motion, the foundation for it, the arguments undergirding it, actually have some teeth. If Charlie Adelson's defense can point to instances where strategic decisions were made that may have been beneficial to Donna Adelson and not to Charlie, that's a huge problem. Let me spell it out for you. Rashbaum apparently was retained by both Donna Adelson and Charlie Adelson as he was representing Charlie Adelson at trial. Now, is that on its face a problem? No. Many times lawyers will represent members of a family. Here it was a little bit different because Donna easily could have been implicated in all of this. Again, not necessarily a problem unless Rashbaum, and they can find instances of this, Rashbaum was making decisions that strategically benefited Donna and may have even marginally affected Charlie's case. When an attorney is representing a client, he has to do so zealously and without conflict. And you might even argue without even the appearance of conflict. So if any decision was made, and the defense can find this, the attorney's now representing Charlie Adelson, if any decision was made during that trial that you could somehow say affected their representation, strategically either was disadvantageous or appeared to be such in Charlie's case, because of the representation, simultaneous representation of Donna, we've got a problem. Could this be something as simple as having her removed from a witness list? I don't know. I don't know if that goes far enough. But I do know that they're going to actually have to show some effect, some bias, not just suspicion, not just speculation, not just possibilities, but actual harm in a decision that was made. But what do you guys think? Do you think it is enough to earn Charlie a new trial? Or do you think this is a bunch of kind of post-conviction spinning of wheels? Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask you one very small favor, and that is if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we can, and best the way that we can do that is through your support. And don't forget to check out Courtroom Confidential as a podcast. Join our community on all major podcast platforms. Also making headlines this week, trial began this week for David Pierce, a Hollywood wannabe producer, and Brant Osborne, a failed actor, who are charged in connection with the 2021 deaths of two women after dumping their bodies at two separate hospitals. Los Angeles model Christy Giles, age 24, was already dead when she was found outside a Southern California hospital in Culver City. Architect and interior designer Hilda Marcela Cabrales Arzola, age 26, was in critical condition when she was discovered outside Kaiser Permanente West Los Angeles Hospital just hours after Giles was dropped off. Her family later took her off life support just a day before her 27th birthday. Both women had been drugged with a fatal cocktail of fentanyl, ketamine, cocaine, heroin, MDMA, and the rape drug GHB, police said. Their deaths were classified as drug-induced homicides by the Los Angeles County Department of Medical Examiner coroner. In July of 2022, Pierce was charged with 2 counts of murder and 2 counts in the sale, transportation, and furnishing of a controlled substance. Osborne was charged with 2 counts of accessory after the fact. In addition to the murder charges, Pierce has been charged with several counts of sexual assault against a total of 7 victims spanning a 13-year period. Opening statements took place on Thursday. For more in-depth coverage of this tragic case, please check out our Case Notes episode linked in the description below. Karen Reed played a central role in arguments during a pretrial hearing for murder suspect Brian Walsh, who is charged with murdering his wife, Anna, and disposing of her body, which has never been found. On Wednesday, Walsh's attorney shifted focus from their client's case to seeking documents related to the Reed investigation. Part of the evidence introduced at Reed's trial was evidence of vulgar and inappropriate text messages that the lead investigator, Massachusetts State Trooper Michael Proctor, had sent to colleagues about Reed. Proctor, who also led the investigation into Anna Walsh's disappearance, is scheduled for a department policy violation hearing on January 15th. Walsh's defense argued that Proctor's conduct in the Reed case highlights potential bias in their client's case. Attorney Larry Tipton claimed Proctor's disparaging remarks in one case suggest a pattern of bias that could affect other defendants, including Walsh. According to Court TV, Judge Diane Frenier ordered the defense to file a detailed explanation of how the requested documents pertain to Walsh's defense ahead of a February 14th continuation of the hearing. On February 14th, Judge Frenier is also expected to hear arguments regarding DNA testing on key evidence. Some samples, unable to be processed by the Massachusetts lab, were sent to a Virginia lab, which informed the defense that expected observation of the testing would cost an additional $20,000. Judge Frenier said the lab could do the testing, but the Commonwealth would have to foot the bill if the defense wanted to observe. Walsh is scheduled to stand trial in October. Orrin Alexander, one of 3 wealthy Alexander brothers, charged with forcing dozens of women to have sex with them, was not accidentally flown by the U.S. Marshal Service on Tuesday to New York before his bond hearing in Miami, but he almost was, according to the Miami Herald. U.S. Marshals in New York mistakenly issued a transportation order to bring Orrin from a federal lockup in Miami to a detention center in New York City, according to a spokesman for the agency. On Tuesday morning, Marshal deputies were transporting Orrin in a vehicle to Miami International Airport when they realized he still had a bail hearing in Miami on Tuesday afternoon. On Wednesday, Orrin canceled his bail hearing, opting to hold it in Manhattan federal court next Wednesday. He also agreed to his removal from federal custody in Miami to New York City where he and his two brothers were charged last month in a sex trafficking conspiracy indictment. As of Wednesday afternoon, the three brothers remained in the Miami Federal Detention Center. According to the FBI and federal prosecutors, 42 women have accused at least one of the three brothers of sexual assault in the sex trafficking conspiracy indictment, which was filed in Manhattan federal court. All three are expected to enter not guilty pleas at their eventual arraignments in New York City. New Los Angeles County District Attorney Nathan Hochman met with the Menendez brothers' family last week as he continues to review their bid for freedom 35 years after they were convicted of killing their parents. Hochman, who took office in December, said Friday that he had a productive session with the family members who shared their thoughts with him on whether the brothers should be released. Court TV reports that the meeting lasted about 3 hours. Hochman said Friday he is still reviewing thousands of pages of prison records to analyze the rehabilitation aspect of resentencing. Evidence of rehabilitation could include not engaging in illegal activity while in prison, starting organizations that helped other prisoners, and using the time to improve oneself, he added. A Broward judge was set to consider a flurry of motions Monday in the case of South Florida rapper YNW Melly, but the hearing came to an abrupt halt when discussions over the investigation into his lead defense attorney, Raven Liberty, arose. As discussions continued into Tuesday, Melly, whose real name is Jamel Demons, was given until February 18th to decide if he would keep his attorneys, given the fact that Liberty is under investigation by the Broward Sheriff's Office. Though authorities have not provided more details, one lawyer said Monday that it was for tampering, according to NBC News. DeMons is a member of a music collective that included two of his childhood friends. He's accused of fatally shooting both friends after a late-night recording session and staging the crime to appear as a drive-by shooting. Melly has been in custody since his arrest in February 2019, and his first trial ended as a mistrial in the summer of 2023. Before we get to what's on the docket for next week, I wanted to take this time to thank you all for your support. The love from our growing community has been absolutely amazing. But I wanted to give a special shout out to Lego People for their fantastic review on Apple Podcasts, as well as to our CC crew members, Teeny Grandma and Louisa 3707 for their thoughtful comments on YouTube. Keep them coming. We absolutely love hearing from you. On the docket next week, Tad Cullum, one of the defendants in the murders of Kansas mothers Veronica Butler and Jillian Kelly, will return to court on Monday, January 13th. In December, after a 2-day preliminary hearing, a judge ordered Cullum to stand trial on charges including 2 counts of first-degree murder. If convicted, he could face the death penalty. Long Island architect Rex Heuermann, charged in connection with the deaths of 7 women, including the Gilgo 4, whose remains were discovered in the notorious Gilgo Beach killings, is scheduled to appear in court for a hearing on Wednesday, January 15th. And finally, this Monday, we are doing a very special live episode for our top 10 trials to watch in 2025. Please tune in at 5 p.m. Pacific, 8 p.m. Eastern. We would love to hear your questions and comments in the chat as we go through the cases we expect to make 2025 a year to remember. And don't forget to check out our episode from last week where we broke down the top 10 cases from 2024. That is it for us this week, folks. I am your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.